Hello, my name is Nissa Towsley. I'm the Education and Outreach Manager for the VCU IRB, and in this video, I'm going to cover the topic of reconsenting children who reach the age of majority while participating in a research study. In this video, we're going to review relevant definitions, including definitions of children, parent and guardian, and permission and assent. We'll review requirements for parental permission and assent for research involving children. We'll discuss requirements for reconsenting children who reach the age of majority during a research project. We'll also discuss the requirements for applying for a waiver of consent, as well as discussing options for anonymizing data to obviate the need for reconsent. In this first section, we will review definitions, which will be important for understanding how the regulations apply in these cases. The regulations define children as persons who have not attained the legal age for consent to treatments or procedures involved in the research under the applicable law of the jurisdiction in which the research will be conducted. In other words, who meets the definition of a child will vary depending on the location of the research, so it is always important to consider where the research is taking place to determine if you will be including children in your research project. In Virginia, children are generally individuals who are under the age of 18. There are exceptions for emancipated minors, who are individuals who are considered to have attained the legal age of consent, regardless of their actual age. And there are also exceptions for certain procedures to which minors are legally allowed to consent. As an example, in some states, adolescents may obtain contraception without the permission of their parents. If a research protocol involves the comparison of different contraceptive methods, it may be possible for the IRB to determine that for the purposes of the research, these adolescents do not meet the definition of a child. The regulations also provide definitions for parent and guardian. Parent means a child's biological or adoptive parent, and guardian, on the other hand, means an individual who is authorized under applicable state or local law to consent on behalf of a child to general medical care. When permission is not being provided by a child's biological or adoptive parent, investigators should confirm that the individual intending to give permission is the child's legal guardian. In general, the individual who has legal custody of the child would be considered to be the child's legal guardian for the purposes of providing permission for research. Investigators are advised to request to see documentation of the person's status as a legal guardian before enrolling the child. The next two relevant definitions to discuss are permission and assent. Permission means the agreement of the parent or guardian to the participation of their child or ward in the research. Assent, on the other hand, means a child's affirmative agreement to participate in research. It's important to note that mere failure to object should not, absent affirmative agreement, be construed as assent. The difference between permission or consent and assent is that parental permission and consent are legally effective, whereas assent is not. Obtaining assent, however, is still an important step in research involving children. We demonstrate the Belmont principle of respect for persons by seeking a child's affirmative agreement to participate in a study insofar as they are capable of doing so. We'll talk more about the requirements for permission and assent in the next few slides. The regulations outline specific requirements for parental permission and assent for research involving children, so we're going to discuss those in the upcoming slides. The regulations state that the IRB shall determine that adequate provisions are made for soliciting the permission of each child's parents or guardian when conducting research involving children. The parental permission process and form must contain all the required elements and applicable additional elements of consent from Subpart A. Permission must also be documented in accordance with the requirements at 45 CFR 46.117, which is to say that all signatures required by the regulations and institutional policy must be obtained. The number of parent signatures, either one or both parents, depends on the nature of the study and the availability of the parents. Generally, for minimal risk research, one parent signature is required, but the IRB may consider the need for both parent signatures based on the context of the study. The same is also true for research that is greater than minimal risk, but holds out the prospect of direct benefit to the participant, which is not available outside of the research context. In those cases, again, only one parent signature is required, but the IRB may consider the need for both parents to sign. For greater than minimal risk studies without the prospect of direct benefit, both parents must provide permission. The requirements to obtain both parent signatures are not applicable if one parent is deceased, unknown, incompetent, or not reasonably available, or when only one parent has legal responsibility for the care and custody of the child. The regulations also stipulate that the IRB shall determine that adequate provisions are made for soliciting the assent of children when, in the judgment of the IRB, the children are capable of providing assent. This means that IRBs have a fair amount of flexibility for determining when assent is required, and if so, how it should be obtained. At VCU, our general guideline is that you must obtain assent from children who are 7 years of age or older. However, there are a few circumstances under which assent may not be required. First, assent may not be required if some or all of the children to be involved in the research are not capable of providing assent due to the severity of their condition. This needs to be explained in the IRB application and justified by the investigator. Assent may also not be required if the research holds out the prospect for direct benefit to the child participant. Finally, assent can be waived in the same way that consent can be waived by requesting such a waiver from the IRB and adequately justifying the waiver by satisfying the 5 waiver criteria. It is important to note that any waivers of assent may be applied to all children in the study or just some of the children, depending on the circumstances. It should be made clear in the IRB application when assent will be obtained and from which children in the study. The regulations have no firm requirements for the content of an assent discussion, nor do they have requirements for documenting assent. The IRB is therefore responsible for determining not only when assent is required, but by what means it will be obtained and documented. At VCU, we have templates available for assent forms if you want to take a written approach. These templates can also be adapted to verbal scripts for obtaining verbal assent. Regardless of what methods you propose to use, the methods should be clearly described in the IRB application. Finally, when obtaining assent, it is important to respect the child's wishes to the extent possible. When a parent refuses to provide permission, you may not enroll the child, even if the child provides assent. However, on the other hand, if the parent does provide permission, but the child refuses to provide assent, then the child's wishes should be respected and the child should not be enrolled in that case either. Some research projects may involve people who meet the definition of children at the beginning of the research project, but who later reach the age of majority or otherwise do not meet the definition of children at a later point in the study. We're going to talk about requirements for reconsenting these subjects. Why is it important for us to talk about reconsent for children who participate in research but later become adults while still participating in the research? According to the OHARP guidance, informed consent should be viewed as an ongoing process throughout the duration of a research project. Even for research involving only adults, it is important to continually check in and reaffirm someone's consent to participate in a study. But for research involving children, this is especially important because once someone no longer meets the definition of child, they are no longer subject to the requirements of Subpart D, which is the part of the regulations outlining requirements for involving children in research, and instead become subject to the requirements of Subpart A, which outlines the basic requirements for informed consent. Basically, once someone is no longer a child, parental permission is no longer a legally effective form of consent, and instead the subject must provide their own legally effective consent. Again, we uphold the Belmont principle of respect for persons when we reconsent former child subjects because this reconsent process affords the now adult subject the opportunity to make their own informed decision rather than defaulting to the decision originally made by their parents. So the next question is, when is it necessary to reconsent? According to SACHARP and OHARP guidance, minors who are initially enrolled with parent or guardian permission and then reach the age of majority must provide legally effective consent if the project continues to meet the definition of research involving human subjects. So let's review the definition of human subject. The definition of human subject includes obtaining information through intervention or interaction, or obtaining, using, studying, analyzing, or generating identifiable private information or biospecimens. Therefore, even if the interactions and interventions in your study have ceased, if you maintain a former child subject's identifiable information, you are now obligated to obtain reconsent from the now adult subject. The next question is how you can reconsent a subject. The best advice I have for you is to plan ahead. When you are developing a protocol that will include minors who may age up while meeting the definition of human subject, you should make a plan to reconsent. And keep in mind, again, that you don't have to be intervening or interacting with the subject for them to still be considered a human subject in the research. If you maintain their identifiable information, you would still need to obtain reconsent from those subjects. So you need to make a plan for that. So for example, you should develop an adult consent form if you don't have one for your study already, so that you can utilize this with the now adult subjects to obtain their consent. You should also develop a plan about how to contact the now adult subjects and obtain consent, especially if your study takes place over a long period of time. It is important to consider how it will be feasible to follow up with the now adult subjects to obtain their consent. Some common examples for methods of reconsenting include, most obviously, reconsenting the child at the time of their next study visit. This is easy to do if your study still continues to involve interactions or interventions. It's not necessary to reconsent the child immediately upon them turning 18, but you should do it at the earliest opportunity. So if you have children, or if you have former child participants coming in for study visits, you should reconsent them at the earliest opportunity. You can also obtain consent remotely if you're not going to be seeing these children again or won't be seeing them for a long time. Some options for remote consent include conducting consent over the phone, and you could request a waiver of documentation of consent so that you don't have to obtain signatures. If you do have to obtain signatures, there are other options for e-consent, such as using DocuSign. And you can also mail a consent form with a return envelope to a subject, but this should likely be coupled with some kind of phone call or other sort of discussion with the subject so that they can get their questions answered and make an informed decision. There may be instances where obtaining reconsent is not practicable or feasible. So we're going to talk about waiving consent, which is to say, waiving the requirement to obtain reconsent from now adult subjects. So what if you're in a situation where you can't reconsent? OHRP guidance states that the IRB may consider, if appropriate, a waiver of consent in order for the subjects to continue their participation in the research. In order to waive the requirement to obtain reconsent, you have to request a waiver of consent from the IRB and must justify the waiver according to 46.116F. That means justifying the waiver adequately by responding to all of the questions on this slide. And on the next slide, we're going to talk a little bit more about when waivers might be appropriate. When is it appropriate to waive the requirement to obtain reconsent from now adult subjects? If research involves ongoing interactions or interventions, a waiver is not likely to be appropriate. You won't be able to satisfy the practicability criterion because it is likely that you could obtain reconsent from the now adult subjects since you will be seeing them regularly. On the other hand, if research is limited to analysis of identifiable data, a waiver may be appropriate. For example, a longitudinal study enrolling children as infants means that contact info might be obsolete, people might be lost to follow-up, there may be increased risk for recontacting subjects, and other reasons. It's always important to consider the context of your research and the true feasibility of obtaining reconsent for subjects. It can't just be merely inconvenient for you to obtain reconsent from the now adult subjects. It needs to be truly not feasible. Besides obtaining reconsent or applying for a waiver of consent, there is a third option for dealing with the information you retain on now adult subjects. Reconsent is only required when the now adult subject continues to meet the definition of a human subject. And if you think back to that definition of human subject, it requires that the remaining data about the subject is identifiable. Therefore, anonymizing the data means that the now adult subject no longer meets the definition of human subject, and therefore consent is no longer required. Keep in mind, though, that if you utilize this option, you need to truly anonymize your data, which means removing any type of identifiers or combination of information that could be used to re-identify the subject. If there's any follow-up involved in your study, it may not be a good idea to take this option. But if you have completed your study and you're in a data analysis situation, but you no longer require identifiers, this might be the easiest option, and it can avoid the question of obtaining reconsent. Thank you for viewing this video on the topic of reconsenting children who become adults while participating in research. I wanted to finish this presentation by showing you a slide with some resources on this topic that can help you if you are in this situation. Of course, there are the regulations themselves, as well as OHARP FAQs on children in research. There's VCU's written policy and procedure on the topic of children in research. And of course, your most important resource is IRB staff, and you can contact us by following the link on this slide. Thank you very much for listening and viewing this video. I hope it was helpful.